हेलो एवरीवन, वेलकम टू लीगल प्रूडेंट स्टडीज चैनल। मेरा नाम राहुल कुमार गुप्ता है। आज की इस वीडियो में बात करेंगे फर्स्ट टॉपिक ऑफ कॉपीराइट लॉ अंडर इंटेलेक्चुअल प्रॉपर्टी राइट लॉ 2। लेट्स हैव ए लुक ऑन सेक्शन 13 एंड 16 ऑफ कॉपीराइट एक्ट 1957। Section 13 talks about work in which copyright subsists. Subject to the provisions of this section and other provision of this act, copyright shall subsist throughout India in the following classes of work. That is to say, original literary, dramatic, musical and artistic work, cinematograph films and sound recording. You can go through section 2 of this act to know the meaning of these rights. Okay. Section 16. No copyright except as provided in this act. No person shall be entitled to copyright or any similar right in any work, whether published or unpublished, otherwise than under and in accordance with the provisions of this act or any other law for the time being in force. But nothing in this section shall be construed as abrogating any right or jurisdiction or restrain a breach of trust or confidence. So there is a topic, confidentiality of breach of agreement. So we'll cover several cases on that topic too. Let's cover first case. Donoghue versus Allied Newspaper Limited, 1937, Allahabad case. So this case is based on idea expression dichotomy. This expression dichotomy talks about mere idea is not a subject matter of copyright unless that idea is expressed. So on this dichotomy, idea expression dichotomy, this case was based. Donoghue versus Allied Newspaper Limited. In this case, Mr. Falstead was implied on the behalf of Donoghue, and it was signed a contract agreement to publish an article in newspaper. The agreement was signed with News of the World. So to publish a article, namely My Secret Cycle by the Donoghue. So Mr. Falstead was work on the behalf of Donoghue, and this article was published in the newspaper, and with some addition, and Mr. Donoghue was used to communicate his idea to Falstead. Then this idea was published in the newspaper, but Mr. Donoghue never retained this idea. So after publication, Mr. Donoghue claimed that this is my idea and it was infringed. It was published without my permission, modification. So in this case, it was held that mere idea is not a matter of subject matter of copyright unless that idea is expressed. So in this case, Mr. Donoghue was used to communicate his idea to Falstead, who was employed by Donoghue to complete the work. There is a quotation. Let's have a look on that quotation to understand. Here you can see If the idea, however brilliant and however clever it may be, is nothing more than an idea and is not put into any forms of the word or any forms of the expression, such a picture or a play, then there is no such thing as copyright at all. It is not until it is, if I may put it in that way, reduced into writing or into some tangible form, that you get a right to copyright at all. And the right and the copyright exists in the particular form of language in which, or in case of a picture, or in particular form of the picture by which the information or idea is conveyed to those who are intended to read or to look at it. So in this case, the Donoghue who has claimed the infringement of right was used to only communicate to Mr. Falstead, and not used to write anything whatsoever. So in this case, it was held that the idea is not a subject matter of copyright unless it reduced into writing or into some tangible form. So thank you so much for this video. We'll cover next topic or next cases of this topic.